All right, so I'm Ed Walters. I'm the CEO of Fastcase. That's how I know most of you. I'm also an adjunct professor at Georgetown and at Cornell Tech in New York City, where I teach the law of robots, a class about how law changes in the presence of decision-making machines, where machines make decisions that people used to. How does the law change and adapt to that? How do we think about it? So all of these interests are sort of coming together. My legal research nerdery, where we try to use facts and citation relationships and empirical studies to make legal research smarter. The law of robots, how law changes in a world with artificial intelligence and smart machines. And a book that I've edited that is coming out in about a month called Data-Driven Law, which is coming out from Taylor and Francis. I would say the culmination of this also is a new journal at Fastcase called RAIL, the Journal of Robotics, Artificial Intelligence, and Law, which is designed to be something in between like a magazine and a law review, right? So it's faster, it's a little more hot take, and the publication cycle is much shorter, right? So there's kind of a lot of things converging here. And so today's talk is kind of a work in progress. In the interest of full disclosure, it combines a couple of things that we've been thinking about at Fastcase into a single topic, and that is data analytics and artificial intelligence and how that influences the professional responsibility of lawyers. To put it differently, do lawyers have an ethical obligation to learn facts? If the facts are present, do they have an ethical obligation to use them? Where machines can decide things and predictively reach answers better than people can, how does that influence our professional responsibilities as lawyers? And what happens when they're wrong? Because one facet that no one talks about is that both individual practitioners and the machines they use will be wrong all the time. Right? In the past, it's just been lawyers who are wrong. In the future, we'll have lawyers who are being guided by artificial intelligence and software and machines that suggest answers to them probabilistically, and then lawyers who have to make decisions about giving advice to clients. And then, poor clients who then have to make decisions on the basis of that. Right? So it's really kind of a talk about professional responsibility. I don't want to do too much flying car stuff. I'm going to show and tell a little bit. I hope not in a silly way. I'm not going to try and convince you to buy anything that I'm showing, but I will talk about some of the things we're working on that kind of raise this for the purposes of the hypos. So clients bring these questions to lawyers every day. These are sometimes bet the company questions. For families, they are some of the most pressing questions that they ask. Can I keep my abusive husband from getting custody of my child? In this corporate litigation, how much risk does our company face? If I'm hurt in an accident, how much is my case worth in some sense? In contracts, I've got this contract that we're looking at. Is this non-compete clause standard, or is it really onerous? I've received a settlement offer in this litigation. Should I accept it? Clients bring these kinds of questions to lawyers and law firms. In heart, these are data questions. The answer to how much is my case worth is not $1.2 million, because nobody knows what the case is worth. That's a data question. The answer to how much is my case worth is a distribution. Here is the range of outcomes, a bell curve distribution of outcomes in cases just like yours. This is what the settlement values are. Here's the median, here's the mean. Here's a couple of facts that might make your case an outlier, in which case it looks more like these over here. But these are not conjectural questions. These are data questions. And lawyers universally answer them with conjecture, with educated guesses. I mean, if you talk to lawyers about it, they will say, I am basing this decision, I'm basing this recommendation on the basis of my years and years of experience. And I've done scores of these, and I can tell you that when a corporate executive leaves a company, here's the range of numbers for the golden parachute, and yours is inside it or outside of it. But typically the number of data points is like 18 at best, sometimes more like 6. So outside of law, in other disciplines, there is a name for this kind of decision making. It's called hunches. A hunch is nothing more than a guess made without the benefit of data, especially for data type questions. So in the presence of very little data, lawyers have to really make these kinds of decisions all the time. Should I accept the settlement offer? No. I don't really know. So here's the thing about this data in law. It's not that the answers are unknowable. They're not like mystical. They're just unknown. There is an actual distribution of outcomes. We just can't see it all the time. Judicial opinions don't announce them. Settlement values are most times confidential, right? You can't see every contract in the world. But there are increasingly data sets that are available to look at this stuff. Sometimes the data sets are inside law firms or inside universities, because they'll get a collection of things from different law firms. Sometimes the clients themselves have that data. Think about like insurance companies for a second, right? Insurance companies do all kinds of litigation, and they know what the settlement values are. They're confidential, but not confidential to the party that settles it. And parties that settle lots and lots of litigation will have lots and lots of data. I could do a whole hour of soapbox about PACER and its inaccessibility and inscrutability, but there's a lot of data in PACER. So the facts aren't like unknowable. They're not unattainable. They're not mystical or fanciful or something. They're just, for the most part, unknown. So one of the things we're going to see in law over the next 10, 20 years is more and more of these data sets popping up. And it's a cool time because we're now reaching a time where machines are getting pretty good at understanding data, at ingesting data, at finding patterns in data. And I don't care whether you call it machine learning or artificial intelligence or deep learning, the kind of boundaries of those different disciplines don't really matter much to me. But the fact is that as the data becomes more and more available, we will have tools from other disciplines that will allow us to make better sense of them. What does that mean for us? Right? What does that mean for the profession and the practice of law? Doesn't it have to become more data-driven? Don't we have to kind of find out what those answers are? So I'll talk about 2 things we're working on at Fastcase, just as examples of this, not like in a silly way, I hope. I'll just start with a caveat, like don't buy either thing I'm talking about right now, okay? So the first is we're working on this project called the AI Sandbox. And the idea behind AI Sandbox is demystify the tools. Some of the tools are actually pretty easy to use. So IBM Watson has like 62 different APIs that you can use. They used to be this crazy business model where you pay IBM like $900,000 and they'll put a team of 7 people on your problem at $300 an hour, and maybe something comes out of it, maybe it doesn't, but all the risk is on you. No one is going to do that. No one in their right mind is going to do that. Well, that's changed. So now the Cloud Developer Suite for IBM Watson typically is 0 to start. You can start using the APIs right away. The documentation is pretty good, and you pay by the call. So the API calls are like 0.3 of a penny per call. Don't get me wrong, by the way, you can add those up pretty fast. Make 15, 20 million of those calls, and you can run up a pretty good bill. But at least you know what it's going to be. There's no mystery to it. There are tools like TensorFlow that are open source, right? Contract Suite from Let's Predict. The tools are becoming more democratized and more usable. 5 years ago, 3 years ago, it would be crazy to suggest that any of us in this room could use these tools. I'm telling you that today, smaller lift. It's not like booting your computer and launching Microsoft Word, but it's also not a moonshot either. You don't need to have like a team of data scientists to do it. So for an R&D experiment, I'm tempted to call it a shits and giggles experiment, but let's call it R&D for a minute. At Fastcase, we figured out we could probably download the metadata for a lot of Pacer cases for not a super high charge. It was important. We wanted to invest in it, so we spent a bunch of money. So we downloaded the metadata as an R&D experiment for every case filed in America in federal district courts for the year of 2012. 751,000 rows of data. Pretty cool. So just from the metadata, you can see things like who sues whom, what the seasonality of litigation is, trends in the nature of suits. The data is Pacer data, so it's crappy, as you guys know. But even if you don't have full fields for all 751,000 rows, you might have it for like 400,000 rows, which gets to be a pretty good data set. We loved it. We immediately started playing with it, manipulating it, visualizing it, working with nerdy friends of ours to take a look at it, and it kept crashing our computers. I've got a crappy little MacBook, so no surprise that it crashes mine. But even some of our more powerful computers, it was crashing. So we put it on AWS and created an environment there where we could work with it, where we're not going to crash AWS, I hope. And then we started finding new tools to work with it, right? And then we downloaded a couple more years of data. Now I think we've got every case filed in federal courts from 2012 to 2017. It's I can't remember, it's 5 or 6 million cases. It's a really awesome data set, right? And you can now see, for example, what is the seasonality of litigation against McDonald's? How do the cases end? How long does it take? Between the date a case is filed and the date that it closes across time, or with different lawyers, or for different parties, or across different courts. What judge in America has the busiest docket? What judge in America has the lightest docket? Who's the fastest? Who's the slowest? It's pretty awesome. So this is, it kind of spawned this idea of the AI Sandbox, which is just AWS instances that we set up for law firms to put some combination of Fastcase data and law firm data. I kind of can't believe that this is a big deal, but one of the big deals about it is that we'll take a bunch of Fastcase data, judicial opinions, metadata, statutes, regs, whatever it is, and put it into the box, and then hand the keys to somebody else, right? In the old days, data was scarce, and that was the whole product, and you would sell access to it, and you would never, ever, ever want anyone else to have access to it. Data is a commodity. Most of the data is public. We want it to be a commodity, right? The cool thing that people should be thinking about is the software you build on top of it. So we put Fastcase data into the box, and then law firms upload, for example, their billing data to find out who at their firm is most effective at reaching an outcome. They are doing some cool experiments in the AI Sandbox right now. One of them is to create personas for judges. When you walk into Best Buy or any big box store, they immediately, a salesperson, as soon as you walk in, will take a look at you. They will look at your shoes and your watch and your glasses, the way that you're wearing your hair. They'll get a rough sense of how old you are. They'll check out what time of day it is, and then they'll slot you into a persona, right? This is Ed the Returner. This is Tim the compulsive sports buyer, right? This is Looky Lou Tom, who comes in, looks at everything but doesn't buy anything, right? They have these personas for the purposes of selling us. They want to know what to suggest to us. So these law firms are using IBM Watson's Personality Insights APIs to try to understand who judges are. This is Olivia the Originalist, right? So we're going to make arguments of this species before this judge. And you can find it in the judicial opinions. You can see who they are. They will tell you. They write, volumes and volumes of words that you can parse using these kinds of AI tools. And again, like, this is not like a lot of computer science. This is running APIs over text, a pretty well understood discipline. Okay, the second thing I'm going to show, I'm going to do the difficult task of switching from mirrored view to unmirrored view and back again. Is Docket Alarm. So Docket Alarm is a company that we purchased in January. And what Docket Alarm does is it looks at the data. And it says, from Pacer data, from Pacer filings, what can we tell? They use some nifty machine learning to look at individual documents and figure out who the lawyer is, who won the case, what the cause of action is, what the industry is. Mostly from Pacer so far, although we're really pushing it into state courts now. So this is patent cases. If you want to see like who the big patent litigation parties are, from the pleadings, this is who they are. You can see a distribution over time, and you can facet it. If you want to see, for example, what the proceedings for Apple look like, here's how they're filed over months. Here's who the party is for Apple. Most times they are not the patent owner. Most time they are petitioners, right? You can see like how often they get claims canceled, which is what they're trying to do. They're trying to avoid being sued for patent litigation. They're trying to get claims canceled. And then here's how their proceedings end. So when they file petitions, this is sort of how they terminate. Trial not instituted for a lot of them, terminated for some, final written decision, claims canceled, some claims canceled, no claims canceled. So when they're trying to cancel claims, they're trying not to be sued for patent infringement. These are all wins, and these are losses. I don't know. I'm going to say if you are pitching patent work to Apple, you probably want to know this. And, 3 years ago, there's no way to know this. It just doesn't exist, right? So now, and I'm not selling Docket Alarm. Lex Machina does a pretty good job of this. There's other companies that do it. My point is just that the kind of data that you can see about litigation, that lawyers have access to, is not like quantitatively different, it's qualitatively different. The kinds of things that practitioners can see today, fundamentally different than what they could see before. Now, once it becomes seeable, what's your obligation to see it? I don't know. I mean, so I would say, like, again, if you're pitching business, if other law firms who are pitching business to Apple know this, you sort of have to know it as well, right? Just commercially, I think this is the new floor. So there'll be all of these kind of commoditized analytics from Fastcase and Lex Machina, I'm sure others over time. But this is the floor. You have to know this. This is kind of like legal research. In the past, you sort of have to know the lay of the land as far as law goes from a kind of precedential standpoint. You might need to have access to a couple of treatises rather. But I think for the future, it's going to be analytics. You have to know what Apple does. Here's all the law firms that represent them, and you can sort of see how they do, what their rate of claim cancellation is. If you want to see, what firm has the best cancellation rate, or who represents what tech center, you can do that. You can drill all the way down. It's pretty cool. So this is Ropes and Gray, what they're filing when. I don't know, if I was going into a beauty contest, I would probably want to know this stuff. You can do it for everybody, for judges, for parties. If you want to see who the friendliest judges are, you can see it. You can see what their top industries are. I want to know who Kevin Turner is. I can sort of see like how busy Kevin Turner is, how many petitions he's facing each month, what he does with them, how many claims he cancels. Cool. Okay, again, not to sell products to you, but to get a sense of what we're talking about. We're talking about data analytics. I'm not talking about just pie charts. I'm talking about the facts that are behind them. So every time I talk about this, inevitably, especially with lawyers, there's someone who says something like, what are the ethical implications of this? If I use this, what kind of ethics trouble am I getting into? What are the perils and pitfalls of data analytics? Like, it reminds me of this lame conversation we've had for the last 10 years. Like, every CLE that you've gone to for the last 10 years will be like, what are the perils and pitfalls of using social media? What are the perils and pitfalls of using the internet? What are the perils and pitfalls of doing instruction online? It's lame. It's really stupid. And part of the reason for this is that lawyers have a status quo bias. We know this, right? Right? Doing nothing is always ethical for as long as you want to do nothing. Do the same thing you've done for the last 30 years, 100% ethical. If you change in any way, then there is an ethical problem with it. There is some ethical challenge. Right? So this is the status quo bias. You have to keep doing exactly what you're doing in exactly the same way you're doing it. Just the way they did it when your law school professor was in law school, the way Langdell did it, right? But I would just say it's obvious. In a time where the world is changing as fast as it is, isn't it possible that doing nothing is like the most dangerous thing of all? Isn't it possible that in a very fast-changing world where we know a lot more, where our clients are changing, that doing nothing is possibly the most ethically risky thing, or change might be necessary and might be ethically required? Yeah. Okay. So that's kind of the setup. I feel like it's a little loose. I apologize for that, but that's what we're talking about. Like, we're talking about lawyering in the presence of more data in a world where you can see more, in a world that's going to be fast changing. Status quo bias kind of can't be the right answer. It doesn't mean you have to change reflexively, but how do you sort of know what you have to do? So I mentioned before that the world is going to be changing very quickly. I don't think there's going to be a one-size-fits-all answer to the question. And so as we're sort of talking about the ethical obligations and the model rules, I'd like to talk to you about it in a continuum. How people are using software tools and artificial intelligence and data across a continuum that we're not fully at today, right? So from using software as a tool to actually having software doing some branch of legal work, all right? Metaphorically, from like kind of a briefcase to all the way to a managing partner. We'll consider artificial intelligence and data analytics from their simplest to the most complex, and all the way up to the managing partner. I'm not talking about like robot lawyers or anything, by the way. Don't think you're going to walk in and find a cyborg or something. It's not going to be Westworld LLP or something. But it's not crazy to think of lawyers working for machines. We actually have some pretty well-developed industries for this today. I used one this morning when I took a Lyft to the law school. Lyft is nothing but a corporation full of people working for machines. This sounds like hokey or wrong. It's not. There's an algorithm running on a server that tells literally tens of thousands of drivers around the world where to go, who to pick up, how much to charge, where to drive, where to drop them off. Right? This is nothing more than algorithms and machines telling people in the real world what to do. I don't know if we're going to have like Uber for law, but it's not crazy to think that algorithms could be moving a lot of legal work around. All right, so let's start at the simplest level, like the briefcase level. Your data and your software tools are really just tools. They're used that way in a law firm. The model rules of professional responsibility deal with this pretty well. I'm using the model rules, not any state's rules of professional responsibility, but in the model rules, Rule 1.1 is the duty of competence. And comment 8 to the Rule 1.1 says there's a duty of technological competence. It's not just competence in making arguments in court. It's competence in using the tools of lawyering, right? A long time ago, I learned that when doing presentation graphics, PowerPoint, Keynote, you never do slides with a big block of text, so naturally I'll do that here. Rule 1.1, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So this is being interpreted now in a lot of states as, lawyers will need to know how to use the tools of the trade, like legal research, like learning how to use email, learning how to use electronic discovery in very large discovery cases. In the past, it hasn't. Increasingly, it is. I would say also Rule 1.3, a lawyer shall act with reasonable diligence and promptness in representing a client. So when I read this, I think electronic discovery, right? I think if you have like a large volume of documents, it probably would not match the requirements of Rule 1.3 to have an army of paralegals and junior lawyers reading through boxes of documents to try and find something that is not there. It would not be with reasonable diligence and promptness. The cost of it would be astronomical. In a world where we have software that can read and find patterns and identify documents that are responsive or privileged, you probably have now an ethical responsibility to use it. There's going to be some boundary conditions where things are in the middle, but for very large ones, it is now probably ethically required that you use electronic discovery. No one's going to argue that, by the way. Nobody wants to do that kind of work. I'll talk about that in just a second. So, when we sort of think about that continuum, when artificial intelligence can do the work that lawyers used to do, what are the ethical responsibilities? 1.1 and 1.3 are front and center. The duty of competence, the duty of diligence. You can't charge clients like astronomical fees to do things that software could do better or simpler. And we know this, right? And if you sent an associate to do 2 weeks of book-bound legal research instead of using electronic legal research, you wouldn't be comporting with your professional obligations, right? So let's imagine for a moment a kind of an extension of e-discovery, or we can take e-discovery as an example here too, where artificial intelligence or software is doing the work that lawyers used to do. And I'll often say, I don't think that AI is going to replace lawyers or replace law librarians or replace professors, but it will replace the work of every one of those professions. There will be lawyer work that gets done by machines. There will be information professional work in law firms and law schools that is done by machines. And for the most part, that's like brute force lame work that nobody wants to do in the first place, like e-discovery. When I was a baby lawyer, my firm did the ExxonMobil merger. The day that they got the job, they started building a loading dock behind my firm. There were construction workers out there building a dock. And just as they were finishing, the first 18-wheeler pulled up. They had a whole building, filled it with paralegals and lawyers. And I'm telling you, for 18 months, they would unload an 18-wheeler full of boxes and move them into that building. And then the 18-wheeler would pull away empty, and a full 18-wheeler would pull up behind it. 24/7, 365 for 18 months. We don't do this anymore. The data in those trucks would fit in a 10 terabyte hard drive the size of a novel. right? And thank God. The worst possible work for lawyers. I think about some of the maybe cataloging or shelving responsibilities that libraries face that can be done algorithmically. I got in a huge fight at the University of Chicago. I was on the visiting committee for the library, and they were hell-bent to build a $100 million robot library. Have you guys seen this? Yeah, I mean, it's amazing. It's beautiful, this kind of glass dome library with 100 feet down of stacks that are not accessible by humans. It's robots, it's machines that slide up and down the stacks and grab bins and sort of pull them up to the top, up to the surface. My fight was, why on earth would you build a $100 million library when you could digitize the entire collection for about the same price? I mean, your tracks are going to break, the robots are going to need maintenance. You're building a bunker, right? You're not building like a library of the future. I lost that fight. So I don't for a second think that machines are going to take our jobs. I do absolutely hope that they take the worst parts of our jobs. And by the way, there are a lot of people out there right now who are saying, we built artificial intelligence that is a robot lawyer or a robot law librarian. And that's the dumbest thing in the world. So I will avoid saying robot lawyer here. Well, let's talk about the kind of work it would be good at, right? So if in the real world, not in our robot lawyer world, artificial intelligence tools are really good at brute force tasks like e-discovery. So AI always knows where Waldo is. I shouldn't pretend though we're very far in AI. Every time we use it, some part of it breaks or gets something wrong. IBM Watson is seeing this all the time. They had a big contract with MD Anderson to do radiology research to try and detect cancers. It didn't work. MD Anderson spent a ton of money on it. It just wasn't quite there yet. And I think it was oversold and overhyped, and as a result, MD Anderson canceled the contract. So let me introduce one of the biggest AI challenges in Silicon Valley right now with image processing. It's called Muffin or Chihuahua. And candidly, I have a hard time telling myself sometimes. Corgi butt or bread is another visual challenge facing the Valley right now. Sheepdog or mop. I think one of my favorite is Shar-Pei or soft serve. We're not quite there yet. Researchers use artificial intelligence to try to name paint colors. Paint colors have these names like Toast of New York, right? So they put AI tools on the task of naming paint colors.
Thank you.
Thirdly, I think they got it right. Stanky Bean, I don't know. I grew up in Louisiana, and I think I knew a kid named Stanky Bean.
I think I had an apartment with Dorkwood.
Right. I painted my office Dorkwood. Very fitting. So we're not quite there yet, right? I mean, artificial intelligence, very good at brute force tasks. There's some kind of obvious things that maybe your 5-year-old kid can do that artificial intelligence can't do very well. Although my 10-year-old really likes burble synth. So we shouldn't pretend like it's robot lawyers or you're going to be shaking hands with an android or anything. But we will use some of these tools in the practice of law, in managing libraries in the academic setting in the future. How should we think about it? So as artificial intelligence begins to take on some of the work that lawyers previously did, I sort of think of Model Rule of Professional Responsibility 5.3, the duty to supervise. So the rule says, with respect to a non-lawyer employed or retained by or associated with a lawyer, and I hate the term non-lawyer, but here they're talking about professionals in the firm who don't have a law license, paralegals or others. A partner shall make a reasonable effort to ensure that the firm has, in effect, measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. And B, a lawyer having direct supervisory authority over a non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. So basically it's saying, like, look, if you have a law license, you are going to be held responsible for the actions of every person who works for you. You need to make sure that their actions are compatible with your ethical obligations as a lawyer. You, in some sense, are like, in a respondeat superior way, responsible for the actions of people who are doing legal work for your law firm. Classic law of robots things, by the way. In the past, that has always been people. In the future, it'll be some combination of people and machines. Will lawyers and law firms have an ethical responsibility to make sure the machines are acting in ways that are compatible with their professional responsibility? I would say yes. That seems like a very simple substitution for me. Why shouldn't you be? And why does that matter? Do we think you're going to have like rogue AI? No, but you might have algorithmic bias, for example. If you're trying to draw patterns from data sets that are themselves biased, you will get results that are biased. In fact, some people are worried about kind of this feedback loop, where machines take biased data and then create more biased data, and other machines use now this double biased data to create even more biased data. And it doesn't have to be like explicitly biased. You know, sometimes you can have like these redlining issues where people are making judgments based on things that aren't race, but they might be your zip code. And the zip codes correlate very strongly with race. There's a case in Wisconsin, state versus Loomis. In Wisconsin State Court, the courts were using an algorithm to set bail. They had purchased software that was supposed to set bail without regard to protected class issues like race or gender or age. The idea was that it was going to truly look at the flight risk and recidivism risk of individual defendants and set bail in a way that was clean and stripped free of human biases. So in one case, a defendant got a very high bail setting, and the defendant's Loomis, and Loomis's lawyer said to the court, "Why is the bail so high?" And the court said, "I don't know. Software says so." So his lawyer says, "Great, show me. What factors did you take into consideration when setting bail for my client?" And the court said, "Don't know." So the defense lawyer sued and said, "You got to show me what's in the black box." The court went to the company that made it, and the company said, "Trade secret. You can't see what's in the black box. We spent years developing this. Our algorithm is proprietary. You can't see what's in it." So the court went back to the defendant and said, "They said we can't see. I guess the case is over." So it went all the way up to the Wisconsin Supreme Court. And the Wisconsin Supreme Court copped out. I think you have to call it that. Their decision basically said, look, the judge in this case set bail exactly the way the robot told it to. It took exactly the machine's recommendation. But it didn't do it as a vote. It was just considering the advice of the machine and used other factors and ultimately set the bail at the exact same price for bail. And so because the judge was using independent judgment, you can't see what's in the black box. Don't think this isn't coming up again, by the way. New Jersey has algorithmic bail setting. This will happen again and again. You can't see what's in the black box. When law firms use algorithms, they will have a responsibility, I think, to make sure that the algorithms that do work that traditionally lawyers did will be held to the same ethical responsibilities that their law firm is. And that's probably right. The challenge is, how do you? I don't think that most lawyers, or most of us, would be in a position to be able to supervise the AI. Most times what we'll have is some probabilistic understanding that machines do a pretty good job of this, which I'll talk about next. So as machines and data are relied on more for higher end work, as they start to do work that requires more judgment, as we rely on them to try and figure out whether a client should accept a settlement offer or what number they should pitch in a settlement. There's going to be all kinds of cases where lawyers disagree with machines, where the AI produces an outcome. Maybe it can explain why, maybe it can't. And lawyers in law firms, or information professionals in law firms, or people in law libraries will say, that just doesn't seem right to me. So here's the challenge. How do you know when to listen to the machine and when not to? How do you know when to say, I don't recommend that you accept the settlement offer, even though algorithmically the machine says you should? So as a matter of professional responsibility, but also as a matter of insurance, we will have this kind of normative pull of evidence. We will see over and over again that machines produce outcomes that are more precise and more informed than people do. They won't be using 18 data points. They'll be using 18 million data points. So their rationale will be more informed. But there will certainly be cases where people say, it doesn't sit right with me. So imagine a case, for example, where algorithmically software says, this settlement offer is in the 90th percentile of other settlement offers that have been accepted. It's on the high end. It's a very high settlement. And your chances of succeeding when you go to trial in this court with this judge at this time are about 15%. Take the settlement offer. And the lawyer says, I think we're going to win. I mean, I know no lawyer would let their arrogance get the better of them in a case like that, but it could happen. Okay, so the machine says settle the case. The lawyer says, I think we should try it. Even in the presence of this recommendation, go for it. I'm an awesome litigator. We're totally going to win. And then the client loses. Is there a claim for malpractice there? When it's understood the machine has been right time and time again based on data, and the lawyer says, let's try the case based on hunches, is there a malpractice action there? Or in reverse, right? The machine says go for it, and the lawyer says, look, I don't think we're going to win. Subjectively, based on my experience in ways that I can't even articulate, my gut says we're going to lose this case, even though the machine says go for it. And then you go for it. Is there some liability on the software manufacturer or the data provider? Or is it all on the client? If the client makes the decision, do we care? Do we have that kind of Loomis move where you say, look, it's ultimately up to the client anyway? Last question for this. If the data is available and the lawyer makes the decision in the absence of data and is wrong, but the data would have shown conclusively that the answer was otherwise, is there a malpractice event there? Duty of competence, duty of diligence, maybe. In fact, in the future, likely. There's a great paper by Oren Kerr and Jason Millar called Delegation, Relinquishment, and Responsibility that deals with these kind of professional disagreements between people and machines. And I would highly recommend it if you're interested in this. It kind of works the contours of all the different permutations of people disagreeing with machines and being right or wrong, or cases where people agree with machines and both are wrong. Very good paper. I think the last thing I'd like to say about this is just, the negligence cause of action is a tort. It requires kind of unreasonableness. Same thing with the model rules of professional responsibility. You'll see time and again, it says a lawyer must take reasonable steps to X or Y or Z. It's basically setting this up under a kind of a negligence-based reasonableness standard. But what's reasonable for lawyers today might not be reasonable for lawyers 5 years from now. Again, similarly with the ability to have this data, this software you might have a professional responsibility to use it. Is this a frontier? No. We've done this lots of times. Imagine, for example, shepherds or Keysight, right? I'm tempted to say, or a bad law bot. So a citator that is for online software. Lawyers 200 years ago wouldn't have a professional responsibility. They wouldn't be liable from a malpractice if they cited a case that was overturned, because there's no way to know the case has been overturned. But starting in the 80s, when you have books that can tell you, or I guess starting in the 1900s, when you have books that can tell you, you might have a responsibility to use that book. It's just data. You know, in the more recent era, if you have the ability to shepherdize a case online very quickly, you have a professional responsibility to find out that the case has been overturned before you cite it in the case, right? This is just software that does something that human lawyers would have done in the past. Read all the subsequent cases to try and figure out whether it's still good law. It's doing algorithmically now with some editorial help what digests would have done in the past. So what's reasonable here will change over time. The presence of data analytics, the presence of software that can help, the presence of software that will be a good guide and understand the full data set instead of limited anecdata might change what's reasonable, might change the definition of professional responsibility and negligence. The last thing I'll say is that you probably will have in the future software that is doing the work of a managing partner. You're not going to work for like Watson LLC, but you might have very substantial roles inside the firm being done by managing partners, and there'll be a greater responsibility than ever to understand what they're doing. For the model rules of professional responsibility, for Rule 5.3, your firm is going to be responsible for everything in the black box. AI is not yet very good at explaining how it comes up with stanky bean. Okay, it just does. There's a branch of artificial intelligence now called XAI, explainable artificial intelligence. It's basically AI tools that explain how other AI tools work, what factors it considers in a way that is kind of human readable and human understandable. I don't, by the way, think we're very far away from AI creating math that they can't explain to us, branches of calculus that we don't yet have the vocabulary for. So I think explaining what's in the box might be hard. At this level also, there's a intersection with the rules of UPL, unauthorized practice of law. So in all 50 states, the unauthorized practice of law is illegal. In some states, it's a felony. Practicing law without a license, practicing law in a jurisdiction in which you're not licensed, very serious offense. So naturally, because we take it so seriously, there's a great definition of what constitutes the practice of law. The last are from those who have studied this, who know there is no definition at all what constitutes the practice of law. Some people say if a machine can do it, it is not the practice of law. That definition is on a collision course with machines. So I would just say, like, this is something we should keep an eye out for. We will have some very hard questions about the unauthorized practice of law by machines. Again, not new. TurboTax does this. If you are filing your taxes with TurboTax, there's a lot of legal advice in there about what you can claim as deductions. Right? This is just rules-based AI or an intelligent agent that is walking you through the process and giving advice. All right, so here's my conclusion. We're right in the cusp of a big change. We don't yet have the answers to these questions, but not because they're unknowable, because for the most part they're unknown. But you have these great empirical legal studies right now that are getting the facts out there, that are getting the data out there. There's all kinds of computer scientists that are building tools that will enable us to understand them. Not wizards, muggles like me. I got a D in calculus, all right? But I can use these tools to understand data in a way that is very simple and very powerful. this will be a big part of our professional lives and the discipline of the practice of law going forward. It'll have to be. The rules will, in some sense, require it. You'll have a floor of data that you have to know, just like using Shepard's. There'll be a ceiling of data that law firms and law libraries will create for themselves using their own data and using these tools in a very customized way. But in this new world, facts matter. Gosh, in this time, for Pete's sake, facts matter. They matter a lot to your clients. They matter a lot to the practice of law. They matter a lot to the discipline, how good we are at it. And data matters. Where are we with the rules? What do they say? I am, I think, coining in this the rule of Keanu. So with data analytics, with AI, you don't have to be Neo, but you can't be Ted. All right, so I think that with that, I'll be happy to take some questions. I ran a little bit long, Elmer, sorry. And again, I'll start calling from the back.
Okay.
Right.
So there's always been an issue with data asymmetry in representation. The big guy with the big firm, the big company represented by the big firm has all sorts of advantages. When I was in law school a dozen years ago, it's still a legal research. You know, how can the plaintiff's attorney using the library possibly compete against a large firm with West and Lexus and every case ever at their fingertips, right?
Hey, guess what? We fixed that. Fist bump.
Right. In some ways, this makes it worse. You talked, for example, about one example was the proprietary data on what settlement range is that an insurance company is going to have. So the example you gave of the plaintiff's lawyer saying, hey, this is 90%, this is the top 90%. Actually, the plaintiff's lawyer is not going to have that data. It's going to be the insurance company making the settlement offer that's going to have that data, right?
Yep.
So there's asymmetry there. There's asymmetry in the firms and the clients they have, the AmLaw 100 firms that are going to be able to afford these technologies. You talked about how Watson's first business model was untenably expensive. So how do you think we get past that? How expensive all this technology is going to be, and which clients are going to be willing to pay for that technology to get to these, data-based outcomes or these data-based decisions? Is that a policy thing? Is that a market forces thing? How do you see us getting through that?
Permission to synthesize your question for the benefit of the recording?
Absolutely.
I mean, I could hand you the mic and have you redo it. But so Craig asked the great question of, will the presence of this software and this data further stratify legal services? Will it make the rich even richer and the poor even poorer? And how do we deal with that? So yes, absolutely. It was the Oakland A's that started the Moneyball trend, but it was the Boston Red Sox that won a World Series with it, right? So it can't help but create asymmetries. On the other hand, many of the people in this room have devoted large parts of their careers to democratizing this kind of information, democratizing the law. You are literally in the presence of the godfather of it. Democratizing the data, I think, will be similar. I think when you see the impact of the asymmetry, you will have things like lawyers in their engagement letters beginning to create, by contract, the ability to use that data and aggregate it. So I would love to see lawyers on the smaller side saying in their retainer agreements, you will allow me to use the anonymized data from this case, and I will use the aggregate anonymized data that I have access to in my representation of you. And I think that's how it has to happen. It's going to be like AHA or somebody that amalgamates data on the other side, or maybe Cornell or Justia or Fastcase or somebody, maybe all of us, right? But the arms race has already started, right? If you look at Burford Capital or DLA Piper, they're using data like crazy, or like Liberty Mutual Insurance, using data like crazy to quantify risk, to understand legal obligations in a way that the rest of us aren't. But everyone else's data is coming. And again, the trend with Moore's Law and everything else is that the tools get more democratized. The data becomes more public. The data becomes more democratized. So if the data model is that we're going to only keep this kind of information in the biggest firms and lock it up so no one can have access to it, especially public data, especially data that you can pull out of things like Pacer, it's just not a sustainable business model anymore. Open is the way it's going to go. Has to.
But on the other hand, limits.
Yeah, Loomis is case one. Sir, I'll come back here.
Thanks. It was a great presentation, and a lot of the stuff I think a lot of people are thinking about now. Do you think that I think what you're describing right now with 1.1 coming, at what point will it flip that the failure to use the technology is what's incompetent? And I think we're starting to see it now. One of the classes teaches civil procedure and searches for where people live, the name of corporations. You start seeing in this instance now a simple Google search would have resulted in X, right? So I just maybe it's more of a comment that where it's when we can rely on the technology, but I think when the technology is so reliable, I should say. But then you've got people like Catherine O'Neill, weapons of mass destruction, sort of saying that actually technology isn't all that reliable.
Right.
At one point, can the lawyer outsource the decision to the data analytics firm? And I use that term consciously because we also require the lawyer to be responsible when he or she outsources jobs to a human lawyer in some other country or some other jurisdiction. The lawyer is still responsible for whatever that person does. I think the analogy is there for technology as well.
I agree. I would just say that, so for the benefit of the recording, the question is how do we know when the tipping point is, when Rule 1.1 and Comment 8 require you to use the data as a matter of professional responsibility in a time where we're not sure whether it's better or not. And I think what the answer for me is that you'll see benchmark studies. Mark Grossman at the University of Waterloo did a very famous study about technology-assisted review in e-discovery, measuring the accuracy and recall of results from e-discovery versus human review, and benchmark it as measurably better. And I think when you have studies like that, that sort of creates the tipping point. It gives validity to the software and gives, I think, more credence to arguments that malpractice has been committed when a wrong outcome is reached. Elmer, I pushed a little past our time. I'm sorry. I should just say I'll stick around for a little bit. This is still kind of a learning discipline for me. I'm sort of work in progress on some of the professional obligations, so I apologize about the somewhat tentative nature of our exploration here together. But it's a lot of fun, and I'm happy to continue the conversation for a little while afterwards. Thank you very much.